Good morning. I'd like to call this hearing to order. The speaker or the chairman has a really good microphone here. Welcome to the subcommittee. It's great to have everybody here, and we're having our first hearing in the subcommittee this Congress. It's great to have the gentleman from Massachusetts. We're looking forward to the gentlelady from New York joining us here in a few moments. And while I'm not a big fan of opening statements, I'd like to just give a quick opening statement talking about the purpose and method of this and future hearings. Today's hearing is entitled Proposed Reforms to Rule 21 and Modern Authorization and Appropriations Process. It's the first of several hearings we'll have, and the aim of these is to explore improvements of how the House of Representatives functions. Today, we want to have a constructive discussion among members about the intersection of the House rules of appropriations and authorization and overall federal spending. At the center of this intersection is House Rule 21. Clause 2 of this rule prohibits the inclusion of legislative provisions in an authorizations bill, while Clause 4 restricts authorizing committees from appropriating legislation that contains appropriations. Rule 21 also prohibits appropriations of unauthorized programs and altering mandatory programs in appropriations legislation. But we all know in practice, the separation of authorization and appropriating can get blurred. It can give rise to disputes between authorizing and the Appropriations Committee, while also frustrating members in their attempts to pursue policy goals that are important for their constituents and our country. So finding potential solutions to address these issues may help the House return to regular order and make our institution more effective at addressing the great issues facing our country today. But if these issues are addressed poorly, we could end up gumming up the process and making it worse. For that reason, I'm honored to have Representatives McClintock, Griffith before the committee. They've put a lot of thought into separate proposals that, among other things, would amend Rule 21 with respect to the current restriction on making changes to the funding of mandatory programs and appropriations bills. Both representatives serve on authorizing committees, and Representative McClintock will also add the perspective of being a member of the Budget Committee. So I'm also honored to be joined by Representative David Price and our own Tom Cole, who serves on our committee but is also an appropriator. And it's great to have the perspective of an appropriator in this process as well. Lastly, I'm honored that that you are here to talk about this. I'm hopeful that members will find this subcommittee to be an inclusive place. We want everybody to feel like they can have their robust discussion here and exchange their thoughts in a very respectful way. I'm encouraged that we have full attendance and look forward to having real, thoughtful conversations on these proposals. With that, do you know where? She's on the elevator. We will just take a pause for a moment and wait on the gentlelady from New York.
You want me to get my out of the way?
Do you want to? I will recognize the gentleman from Massachusetts.
By associating myself with the comments of Ms. Slaughter, in a few minutes. Look, I'd rather deliver my whole statement here. I'm kind of troubled by the proposals that are being brought before the Rules Committee today. Authorizations and appropriations do get mixed up with one another, and that's because we allow it to happen that way. We're constantly adding we're constantly adding riders to appropriations bills and authorizing language to appropriations bills that this committee, provides all the waivers to do. I wish that wasn't a pattern. It's not just unique to when the Republicans have been in control. The Democrats have done that on occasion as well. I think it's a bad practice. But when people talk about we need to get at mandatory spending, I think sometimes people forget that we have the ability to do that if we so choose. There's nothing that prevents us from doing that other than that we don't want to do it. So you don't need to have all these little magical fixes, to mess around with the appropriations process if you want to get at mandatory spending. we can have the committees of jurisdiction do hearings and report, do markups and report out legislation, if that's what people want to do, and we could have a debate, and we could make amendments in order, we could vote up or down on it. That's called regular order. And all these attempts to get around regular order to try to find, backdoor approaches to getting at something that people don't seem to want to do, I think what it does is it could damage the entire appropriations process. And we got to keep this government running, and it already is difficult enough. We can't even get a budget. And the problem with the budget isn't even the Democrats. I mean, the Republicans are having a battle amongst their own ranks about what a budget should be. So at the end of the day, if you want to tackle these issues, we just got to do our job. And I don't like what's being proposed here today. I respect the members who are before the committee, but it's not as if you can't do it. The party in charge can do whatever they want to do, and let the House work its will through regular order. And I don't think these are necessary. So, having said that, and so Louise, I just agreed with everything you're about to say.
All right.
All right, I yield back.
Thank you all.
I yield
Thanks.
time to the gentlelady from New York.
Thank you, Mr. Stivers. I held up by the phone, which is something I'm sure most of you are pretty much familiar with. I do have an opening statement, but pleased to see all of you. All right. The proposed changes to House Rule 21 would fundamentally change the way the chamber's been governed since 1876 and would further inject partisanship into our already fraught appropriations process. Let me be clear, the changes to Rule 21 as proposed would alter longstanding House rules to make it easier to sabotage responsible spending bills. One of the rules changes proposed today would strictly prohibit appropriating money for programs with lapsed authorizations. To take one example, we haven't reauthorized the State Department since fiscal year 2003, but we are very much unlikely to shut down the State Department. The unfortunate reality is there are a number of controversial issues to be tackled in that reauthorization, and in today's climate, it has been difficult to impossible to reach agreement. But we have continued to appropriate money for the State Department because obviously we can't do without it. Under one of these proposals today, if a reauthorization of the State Department couldn't get the support of the Republican House, 60 votes in the Senate, and the signature of the Democratic president, we would be unable to appropriate any more money for the State Department, and the department would have to shut its doors. Under another of today's proposals, we would do away with the age-old prohibition of legislating on appropriations bills. The Republican majority in the House could and would insert cuts to Medicare, Social Security, or food stamps into all the appropriations bills, which would lead all House Democrats to vote against the bills and cause the bills to fail in the Senate and cause the president to oppose them. We would virtually be guaranteeing more full or partial government shutdowns. These proposals are yet another tactic to slash any spending that they choose, even at the risk of turning off the lights at the offices of agencies that protect our national security and keep us safe, such as the Departments of Defense and State, FEMA, NASA, Coast Guard, and the U.S. Secret Service. And not only would these changes impact our national security, they would erode the bedrock of our social contract. The proposed changes are a backdoor way to cut Social Security, Medicare, Veterans Benefits, WIC, Head Start, and the community block grants. Programs that Americans rely on, but the Republicans have been trying to slash for years. And what's more, the proposed changes would make it even more difficult to keep the government open and to avoid shutdowns. In our politicized environment, it is already hard enough to keep the government running with brinksmanship, political ploys, widespread grandstanding. These proposals would make the government shutdowns more likely by weighing down the annual appropriations process with controversial mandatory spending cuts to programs that Americans rely on. We know the massive and sweeping implications that the seemingly small change would make, and we hope that a change like this will not go unnoticed by the media, the advocates, and Americans alike. The larger view is this. It isn't the House's rules that are keeping Republicans from passing bills. The real issue here is the failure to run the House. We have no budget. They won't address the Flint water crisis, our crumbling national infrastructure, the looming threat of the Zika virus, or any critical issues that are challenging us and frightening the public. We can't let this technical change derail our appropriations process that is already overburdened with divisive tactics and antics. So we have real problems to address, and I fear this change would make it even harder than it already is, and I yield back the balance of my time.
Thank you.
Thank you,
And
Mr. Stivers.
oh, thank you. And so you just heard the bells ring, votes were called. We'd like to try to get through as much of the testimony as we can before we take a short recess to let folks vote. The order that I'd like to invite folks to testify is almost straight down the row, except that I'd like Mr. Price to go before Mr. Cole in the interest of bipartisanship. So we'll go Mr. McClintock, Mr. Griffith, Mr. Price, and then Mr. Cole, if that is amenable. I'd like to go ahead and recognize the Honorable Mr. McClintock.
Well, thank you, Mr. Chairman. Thank you very much for holding this hearing today. As Chairman of the Joint Chiefs of Staff, Admiral Mike Mullen warned that in his professional military judgment, our greatest national security threat is our national debt. He issued that warning $4 trillion of debt ago. The interest costs on that debt are eating us alive, $255 billion this year that will accomplish nothing more than to rent the money that we've already spent. The Congressional Budget Office warns that within 6 years, our interest costs will exceed what we're currently spending on the entire defense budget. Last May, Congress adopted a budget that changed this disastrous trajectory and pointed us back to balance by 2024. But having set that course, we then had to stay that course, and we haven't. The budget now awaiting House action doesn't balance until 2026, and only then, if we're able to summon the discipline to stick to these new numbers. Now, in very rough figures, we're now spending about $4 trillion per year. $2 trillion of that's for trust funds, Social Security, and portions of Medicare. When these funds run out of money, benefits automatically plunge. That is a major problem, but it's not, strictly speaking, a budget problem. Roughly $1 trillion is the discretionary spending that's directly under Congress's annual appropriations control. Now, that spending is actually declining. In 2010, our discretionary spending was $1.35 trillion. The budget now before us spends $1.07 trillion. That's down almost $280 billion. The problem is the remaining $1 trillion that Congress does not directly control. That's mainly entitlement programs like food stamps, Obamacare, Medicaid. This spending is exploding. And the only way to control it is to change the underlying laws, something that today's divided government makes virtually impossible. But there is an alternative: to control mandatory spending through the same appropriations process that controls discretionary spending. The problem is our own rules won't allow it. Rule 21, Clause 2B forbids any changes to mandatory spending in an appropriations bill. So I propose permitting appropriations bills to include such statutory adjustments to mandatory spending as are necessary to keep within the enacted budget. Think of it as one-stop reconciliation. It's necessary because spending is a pleasant experience. Cutting spending is very painful. So spending bills pass and reforms necessary to control spending do not. Now, this reform would not give the Appropriations Committee carte blanche to assume the prerogatives of authorizing committees. It would be limited to annual and temporary changes necessary to keep spending in line within the budget parameters. It could be done upon consultation with the authorizing committees, or at least their chairman, and would be pursuant to the budget that Congress has already enacted. A second reform I'd urge you to consider is to gradually revive enforcement of House Rule 21, Clause 2A, which forbids appropriations except for purposes authorized by law. And Ms. Slaughter is incorrect. This is not a new idea. This is in the rules. It dates back to 1837. And it's the mechanism that forces Congress to review its programs periodically. As a program's authorization expires, Congress must revisit it to ask obvious questions. Is it effective? Is it meeting its goals? Is it needed? Is it worth the money we're paying? Depending on the answer to these questions, Congress then renews the program, reforms it, or lets it die. Well, this process is broken down to the point that today nearly 1/3 of our discretionary spending is for programs whose authorizations expired years, if not decades ago. And Ms. Slaughter is correct, some of these programs are vital, but others have degenerated into the outrages often cited by taxpayer watchdog groups. But authorizing committees feel no urgency to revive them because we routinely fund them anyway by routinely waiving this rule. Now, given the backlog of unauthorized programs, such a reform can't be implemented overnight. But the House should express its intention to restore this rule over a reasonable period, first by freezing appropriations for unauthorized programs and ultimately forbidding them. And of course, case-by-case exceptions can always be made by the House. Before we can provide for the common defense or promote the general welfare, we have to be able to pay for them. And history warns us that countries that bankrupt themselves aren't around very long. I believe that these two reforms that we can make by ourselves without action by the Senate or the President are essential to restoring functional control of the purse strings to the Congress. Thank you.
Next, I'd like to recognize the Honorable Morgan Griffith from Virginia.
Thank you very much for the opportunity to participate in today's hearing. I am pleased to come before the subcommittee to discuss changes to Rule 21 and how best to reform the authorization and appropriation process. One proposal I have would restore the ability of members to Congress to offer more limiting language amendments to appropriation bills on the floor. As a background, in 1983, when the Democrats were in the majority, the rules were changed at that point. So this is not a long-standing rule that dates back to the 1870s or 1880s. It was changed in 1983. It was seen at that time, made it harder to make amendments. It was seen at that time as a response to the fact that the Reagan Republicans in the minority were working in a bipartisan fashion with some of the Democrats to get some cuts or limiting language into appropriations bills. The change that I would propose would largely restore the rule that existed prior to 1983 and remain substantially unchanged since it began in 1876, 1880. This change opens up mandatory spending to so-called limitation amendments during the appropriations process as this autopilot spending is currently protected from reductions by Rule 21. See the attachment that I gave you previously, number 1, for the rule itself. My proposal would give members of both parties the ability to offer amendments on the floor and in the Appropriations Committee to cut the amount of money an agency could receive, the number of employees that the U.S. government or its agencies could have, and the amount of money that could be paid to an employee of the U.S. government. Prior to 83, amendments abolishing offices such as Customs Service, reducing the number of naval officers, imposing an employment ceiling on federal employees, etc., were held to be in order under that rule. Now, I'm not saying that we should do all of those things. I'm just saying that we ought to have the opportunity as duly elected members of Congress to do that. Now, I keep in my office a core sample of the rules, and so when I hear folks say that this is a rule that goes back to a certain time, I go to my core sample and look. And our 1880 rule, and I ask you to take a look at the amendment that I have proposed, and I'm going to read you the section, the pertinent section out of the 1880 rule, which was pretty much the same to 1983, 100 years. Nor shall any provision in any such bill or amendment thereto changing existing law be in order, except such as, being germane to the subject matter of the bill, shall retrench expenditures by the reduction of the number and salary of the officers of the United States, by the reduction of the compensation of any person paid out of the Treasury of the United States, or by reduction in the amounts of money covered in the bill, covered by the bill. If you take a look at my changes in 2B and 2C of Rule 21, you will see this language. Except germane provisions that retrench expenditures, one, by reducing amounts of money covered by the bill, which may include those recommended by the Committee of Appropriations by its direction of a legislative committee having jurisdiction over the subject matter, 2, by reduction of the number and salary of the officers of the United States, and 3, by reduction of the compensation of any person paid out of the Treasury of the United States. The order is different, the language is the same. So I think it's important that we take a look at this because we are going back to the system. It's not going to make it harder to make our jobs. If that were the case, it wouldn't have survived 100 years. It will get us back to a system where members of Congress actually have authority to make proposals. Doesn't mean they'll pass unless they can get a majority on the floor. Generally, that means you've got to have some bipartisan support. As my colleague, Mr. McClintock, said, it's impossible to get serious about cutting spending and setting priorities in Washington when our own rules prevent us from doing so. We must modify Rule 21 to open up mandatory spending to the will of the House and eliminate barriers that put mandatory spending outside the reach of the amendment process. We're $19 trillion in debt. We can't continue to shield mandatory spending. Now, you know, we've heard that you can do that with a separate bill, and that's true, but most of the bills that we have that are really the big ones are authorizing for usually 5 years. Sometimes we shorten it to 2 years or 3 years, but it's usually for 5 years. Once that bill is passed, absent getting the committee to go in and say we made a mistake and reverse itself, you have no other way except through the appropriations process with a change in Rule 21 to affect a change. So I don't think it's exactly correct to say you can do it in the authorizing bill. The American people expect us to get it done. We can get it done, but we have to change our rules of operation in order to make that happen. So, I think it's important that for a legislative branch of government to have this authority and this power. I think we've given up too much of our power in many ways. This is one step that brings it back not only to the House and to the Senate, but to individual members to at least make the proposals they think are important. And I've given you an appendix that shows you that while Medicaid, Medicare, food stamps, those are the issues that are going to get all the attention, we have hundreds of programs. Now, I will tell you, this is my list. We don't actually, nobody's ever provided us with a list. We asked CRS how to get it. They told us how to go try to find some of it. This is the list I've been able to come up with on mandatory spending. But when you look at, say, we tried to find the Wild Horse and Burro program, which is mandatory spending, you got this page here, got a little star there, and that might be the program it's in, but you get into sub-programs. And then you've got these 4 or 5 programs over here on this page, which might be the Wild Horse and Burro program. But when I went to try to amend that early in my term here, and I've been here for 5+ years now, I was told, oh, you can't do that except by making a change in the Farm Bill because of Rule 21. So it's not something that just happens once in a while. It happens all the time. Members are proposing changes, eliminating programs, reducing the number of employees in programs, cutting the money, and we are not allowed to do it. That's not the way a legislative body should operate, and I hope that you all will join me in supporting this rule, because whether you're a Democrat or a Republican, this gives more power to the legislative branch of government in the long term and to its members. And that means that in order to be an equal branch of government, we have to have this power, whether the Democrats are in control or the Republicans are in control. With that, Mr. Chairman, I yield back.
The members are advised that there's about 350 members who still haven't voted. We have about 6 minutes left on the clock, so we might be able to get through both of the next witnesses' testimony. I now recognize and welcome to the subcommittee the gentleman from North Carolina, the Honorable David Price.
Thank you, Mr. Chairman, Madam Ranking Member, and colleagues. Glad to be with you today. I appreciate the chance to testify in opposition to this proposed change to Rule 21. I'm here primarily as a representative of the House Appropriations Committee minority, but it's fair to say that the concerns I'll raise are shared by many members of that committee from both parties. I want to begin, though, by acknowledging what I think is the premise of this discussion today, and we can all agree on this. In recent years, the congressional budget and appropriations process has broken down to the point of dysfunction. Budget resolutions are adopted late or not at all. Appropriations bills are stitched together into omnibuses, usually after a series of continuing resolutions that are necessary to avoid a government shutdown. And as the authors of these proposals have highlighted, far too many federal agencies and programs languish without proper authorization. In this context, it's understandable that the idea of radical reforms to the House appropriations process would hold appeal for some members in search of solutions to our current woes. But I believe this is truly a case where the proposed remedy would be a good deal worse than the disease. The rules changes before us today would weaken Congress's power of the purse by undermining its authority to enact mandatory spending and by prohibiting appropriations for programs that, for whatever reasons, are unauthorized. They would further politicize and immobilize the once bipartisan appropriations process by opening the floodgates to mandatory spending changes in the annual appropriations process. And to top it off, they would punish federal employees for carrying out directives under the law. In short, the changes would only exacerbate our current dysfunction, not relieve it. Now, longstanding rules don't automatically have merit. However, in this case, time has proven the 25th Congress correct in separating the appropriations process from the authorizing process through Rule 21 to, quote, prevent delay of appropriations bills because of contention over propositions of legislation, end quote. Now, nothing in Rule 21 has prevented us from enacting balanced budgets over the past 179 years. Instead, such failure has resulted from an unwillingness to compromise on revenues and expenditures. Many of us in this room today were here for the multi-year budget agreements in 1990, 1993, and 1997. They helped produce a roaring economy, and we had 4 years of balanced budgets. We paid off $400 billion of the national debt. Why is that so hard to figure out? Why is that such a hard precedent to return to? I would contend the consequences of the George W. Bush administration's fiscal policies plunged us back into deficit financing through trillions of dollars in lost tax revenue and 2 unpaid-for wars. Then, of course, we had the necessary but expensive counter-cyclical responses to the Great Recession. All of that's contributed to the past 5 years of extremely partisan and largely dysfunctional congressional budgetary politics. The members offering their proposals before us today are attempting to scapegoat Rule 21 for the problems of partisan dysfunction, driven largely by right-wing budgetary ideology. They're trying to change House rules in order to enact long-time priorities that are too politically unpopular to pass through regular order, namely cuts to America's safety net. And meanwhile, they've signed a pledge, of course, not to ever touch revenues. I want to focus on the major changes proposed by the McClintock-Griffith amendments to Rule 21. Both would affect the authorizing and appropriations processes in significant ways to the detriment of both. Rule 21 was set up by the 25th Congress to avoid the delay of appropriations because of conflicts and debates inherent in the establishment of new policy unrelated to the budget. The proposal before you today, offered by Mr. McClintock, would, among other changes, enable a point of order against unauthorized appropriations and allow reductions in mandatory spending to be enacted through appropriations bills. Let me start with the first. Ostensibly, this provision is aimed at unauthorized appropriations. It's put forth as a way to force Congress, under threat of a shutdown, to review unauthorized programs. Now, let me be clear. The solution to the problem of unauthorized appropriations is important, and it's important for the authorizing committees to do their job and reauthorize or eliminate unauthorized programs. But to hold annual appropriations legislation must pass legislation that funds critical authorized and unauthorized governmental functions. To hold that hostage to the inaction of authorizing committees would only serve to create more brinksmanship and manufactured crises. What are the practical implications? Ms. Slaughter's already referred to some of those. Proponents of the change cite CBO estimates that in fiscal 2016, Congress appropriated approximately $310 billion in funding, approximately 1/3 of the budget, for programs operated under expired authorizations. They say that shows Rule 21 needs reform. What the number really highlights is the breakdown of authorizations. But it's certainly not an indictment of the appropriations process, or evidence that most unauthorized programs lack broad bipartisan and bicameral support. So this has already been mentioned. To eliminate such funding through a point of order would force such entities as the National Institutes of Health, National Weather Service, and NASA to shut down immediately, pending action of the authorizing committees. Number of agencies and programs critical to national security would be forced to put up a close sign. The entire U.S. Coast Guard, Immigration and Customs Enforcement, the federal prison system, the Secret Service, Customs and Border Protection, along with federal grants to state and local law enforcement agencies. We'd also have to close a little-known agency known as the U.S. State Department.
Would the gentleman yield?
Yes.
Apparently, they're not going to hold the vote open downstairs. So if we could, and I hate to cut you in the middle of your testimony.
No, that's fine.
But if we could resume there, if we can just go down, and as soon as the last vote, how many votes are we talking? There's a bunch. So as soon as the last vote is done of the 5 votes, come right back if you could. But I don't want anybody to miss a vote. Thank you. We stand in recess.
You gotta go. You want your phone?
Yeah, I might as well take it.
Everybody else was, can you, hello, testing, 1, 2, 3, testing, 1, 2, 3. Testing, 1, 2, 3, testing, 1, 2, 3. You hear it on your headphones? Sort of spoke, it wasn't. So I don't know if she had hers on. See how hot that is?
I'd like to call the meeting back to order and recognize the Honorable David David Price. I'm so sorry that we interrupted you. Please continue.
Thank you, Mr. Chairman. Just to continue where I left off.
You can start if you want to do what you want.
No, I'll start right here in the middle, and we'll wrap as quickly as possible. I know better than to impose any further. Anyway, I was saying the proposed rule would require us to shut down these agencies, these departments. Unless the authorizing committees acted to reauthorize every aspect of these departments or agencies, that's a process that itself is difficult. It's fraught with longstanding partisan divisions. We would be out of business. It's a recipe for chaos. It's a threat to national security. We regularly pass the Defense Authorization Act after the DoD appropriations bill. The proposal before us would jeopardize our national defense by tying critical annual funding to the authorizing process. Further, if a member wants to eliminate an authorized program or department, like the Department of State, for example, they're welcome to introduce an amendment on the House floor doing so and put it to a vote. Nothing stopping a member from coming to the floor during debate on an appropriations bill to strip out funding for a program or agency in that bill. Now, as a senior appropriator, I'm naturally sensitive to major changes in the appropriations process, but I really believe the annual work of appropriations serves the entire institution. It serves our place in the constitutional balance of power, regardless of which party's in power and regardless of who's president. That's why appropriations has historically been relatively bipartisan. And it's why the Congress's place in the constitutional order is compromised to the extent appropriations is swamped by partisan maneuvers. And by that I mean everything from poison pill riders to ideological budget resolutions or politically divisive cuts to unauthorized programs or entitlements that distract from the work of crafting workable annual funding bills. Now, let me just take a final moment to address the proposal before us to allow reductions in mandatory spending in appropriations bills. That's the second major proposal. It should be clear to all political observers that conservative Republicans are pushing this idea as a means of catering to the most right-wing supporters, unrelenting in their desire to slash entitlements and slash our nation's social safety net. And it's not like I'm making this up. This isn't rooted this isn't a new idea. We've seen numerous Ryan budgets. They voucherize Medicare. They block grant Medicaid. They slash nutrition assistance to low-income Americans. We remember President George W. Bush's efforts to partially privatize Social Security. This isn't new. This is another effort to placate the most conservative elements of the Republican Party. Now, there's nothing wrong with scrutinizing our fiscal situation, reviewing spending and tax expenditures, including appropriated and mandatory spending. In fact, we should be doing that systematically, regularly. All elements of the federal budget should be considered as part of a comprehensive budget deal. But we should not single out any one item. The majority party in recent years has singled out domestic appropriations as though that were the entire budget. Now, in this proposal, we're singling out entitlements and moreover, using them to gum up appropriations bills. I really believe today's effort has more to do with conservative ideology than with any balanced approach to budgeting. The only thing currently preventing Congress from reducing or increasing mandatory spending is political will. And any one of these authorizing committees that meets down the hall could gavel into session today. They could report a bill with changes to entitlement programs. The reason they will not is not because of Rule 21. The reason they won't is because members of Congress lack the courage to compromise on long-term spending priorities. So this rules change wouldn't solve that problem. It would only raise the stakes of partisan impasse by attaching such debate to must-pass appropriations bills. Very bad idea. Mandatory spending programs such as Social Security, Medicare, Medicaid, veterans benefits, federal employee retirement and disability, food and income security programs, those are lifelines for millions of American families, many of whom have earned their benefits through years of paying into these programs, through federal service. When Congress originally created these retirement and social safety net programs, it explicitly decided that beneficiaries should not be subject to the vagaries of the annual appropriations process. Further, this provision is biased in favor of reducing mandatory or entitlement spending, allowing only reductions in such spending, never increases, to be included in appropriations legislation. Now, why would we want to do that? Why would we want to tie the hands of future Congresses to adjust entitlement spending as needed on behalf of the American people? After all, these programs exist to provide for the most vulnerable members of society. The rule jeopardizes long-term and future assistance for the poor, the elderly, by favoring cuts over increases or even over minor adjustments, and tying long-term and sensitive entitlement funding like Medicare to annual budgets of agencies like education and labor. So to put it plainly, Mr. Chairman, if the majority wants to cut entitlements, they should put a bill on the floor and have a straight up or down vote. They can do that tomorrow. Everyone in this room knows such an effort would fail because it would be at odds with the will of the overwhelming majority of the American public. So instead of honoring the public's preference in a straightforward manner, we're instead entertaining an effort to end-run the House budget process through a rules gimmick. It's as if the conservative wing of the majority is admitting they can't win the debate straight up. So now they want to change the rules of the game. No wonder people are cynical about our politics. It's clear the existing budget process has broken down. We've passed ideological and unrealistic budget resolutions that make passing appropriations bills nearly impossible. The proposed changes before us today would fix none of this and only make it worse. We must muster the political will to make difficult and politically costly decisions, and that includes, I must say, whoever the next president is, whatever the next Congress looks like. It includes a comprehensive budget plan. And it's got to address the main drivers of our deficit, that is, tax expenditures and entitlement spending, as well as the full gamut of appropriated spending. We have a precedent in the 90s as to what such budget agreements look like. The proof was 4 years of balanced budgets, $400 billion of the national debt paid off. Why is that so hard to understand? I urge my colleagues to reject the proposed changes to Rules 21 and redouble our efforts to address the underlying causes of our long-term fiscal challenges. Thank you, Mr. Chairman.
Thank you very much. And now recognize one of our own on the Rules Committee and a subcommittee chair on the Appropriations Committee, Congressman Tom Cole.
Thank you very much, Mr. Chairman. And thank you, Chairman Stivers and Ranking Member Slaughter, for the opportunity to testify today regarding the proposed reforms to Rule 21 and the modern authorization and appropriations process. As a member of the Appropriations Committee, the Rules Committee, and the Budget Committee, I look forward to discussing whether changes are needed in the current House rules to make the appropriations process better. I find myself in the unusual position as an appropriator of arguing against non-appropriators who want to enhance the power of the Appropriations Committee. I actually joked to my good friend Mr. Price earlier, if we're going to become the new Ways and Means Committee, maybe we could take over those splendid Ways and Means Committee rooms and just swap out where we do our humble work. But as many of you are aware, the appropriations process is vested in Congress by Section 9, Article 1 of the Constitution. Enacting annual appropriations is something the Congress must do under the Constitution. It only follows that House rules providing for consideration of these bills should help, not hinder, the enactment of appropriations bills. One of the largest challenges the Appropriations Committee faces is the decline of the reauthorization process. As we all know, and several members have stated, the CBO reports that $310 billion in funding was provided in the FY16 budget for programs whose authorization had lapsed. In response to these challenges, there have been thoughtful suggestions, some by my colleagues testifying here today. One suggestion is amending Rule 21 to create an additional point of order on appropriations bills that would require unauthorized programs to be left unfunded or frozen as a way to incentivize the authorization committees to enact authorizations. In my opinion, these proposals have serious downsides. First of all, I do not see how additional points of order on appropriations bills will serve as an incentive to authorization chairmen to move their authorization bills. The target's being put on the wrong back. It's also unrealistic to expect that Congress will not fund our national security while awaiting a defense authorization bill, or that Congress will shut down funding for the National Institutes of Health for lack of an authorization, or that no increase will be provided for veterans' health when an authorization isn't moving for whatever reason. The net result would be more pressure on the Rules Committee to provide additional waivers to these new rules. In addition, these changes would create obstacles to rapidly responding to emergencies and would disadvantage the House in relationship to the Senate, which did not have similar rules. If the intent is to incentivize the authorization process, then proposals should address the authorizing committees, not the Appropriations Committee. However, if the intent of the proposed amendments of Rule 21 is to ensure that no objectionable unauthorized programs are funded, there's already a process to prevent this, the so-called Army Protocol. Currently, every appropriations bill is sent to the authorizing committees before being considered in the Rules Committee. If the authorizing committee objects to funding for an unauthorized program, it can already be exposed to a point of order. Rather than expanding additional points of orders that are not likely to achieve their intended purpose and likely to make the appropriations process more arduous, we should focus on making sure the Army Protocol functions as intended. Another set of proposals recommends changing Rule 21 to make it easier to amend mandatory programs on appropriations bills, including a proposal to reinstate the so-called Holman Rule, which was removed in 1983. This rule would allow changes in existing law as part of an amendment to reduce spending in an appropriations bill. These proposals would significantly expand what amendments could be offered on appropriations bills. They would allow appropriations amendments that are legislative in nature, including how agencies and programs are staffed, structured, and compensated, things that are directly under the jurisdiction of the authorization committees and involve permanent changes in law. It would diminish the roles of the authorizing committees, make them less central to the legislative process, and at the same time make it harder to pass appropriations bills. It would involve appropriations bills in more controversies and increase the number of amendments to appropriations bills, which has already exploded in recent years. In 1982, the last year the Holman Rule was in effect, there were 59 floor amendments offered to the 10 appropriations bills brought to the floor. Last year, there were 456 amendments proposed to the 7 bills that came to the floor, an 800% increase. I shudder to think how long it would take to consider an appropriations bill with a whole new category made in order amendments not necessarily related to discretionary funding. In conclusion, I believe that any changes in Rule 21 must be carefully considered. We should consider proposals to change Rule 21 to determine if they will help us achieve our shared goal of the enactment of the annual appropriations bill. From my perspective, I'm concerned that these proposed changes will not necessarily address the real challenges that their sponsors seek to change. At the same time, I'm certainly willing to work with my colleagues to identify changes that will make the process work more smoothly and will ensure that the authorizing committees do their jobs. Thank you, and I look forward to answering any questions you might have.
Thank you very much. Appreciate all of you for being here today and sharing your perspectives on these proposals. I have a couple questions for Mr. McClintock. So can you, you said on the second part on page 3 where we would gradually revive enforcement of Rule 21, Clause A2, how would you propose gradual enforcement? Either we're going to enforce it or we're not, so I want to understand
Well, we don't
what
enforce
you're
it now.
proposing. We don't enforce it now, I understand that.
And again,
Yeah.
the point is this is not some new radical idea as is being portrayed by my colleagues. Quite the contrary. This is the existing House rule, and it has been the existing House rule since 1837. All we're asking is to restore enforcement of that rule, but I agree it does have to be done gradually. We do have a huge backlog now of unauthorized programs that haven't been reviewed in years. I believe that Congress, ought to make its intention clear that the authorizing committees have a certain period of time, a year or two, even a session or two, to review these programs under their jurisdictions and to renew them, alter them, let them die, but to do their jobs. There is no incentive for them to do their jobs as long as we continue to shovel money at them, regardless of whether or not these programs are authorized. And I agree, some of them are absolutely vital. And by the way, the House, on a case-by-case basis, can continue to override that rule, but it would be by a vote of the House. The important thing is that the committees are reviewing the expenditures as they ought to be doing.
Great. Let me rephrase my question. How much notice do you think the authorizing committee should have? You kind of said maybe
I think it would
a
take at
session or
least, I
two?
think it would take at least a session. I think it would take
Okay,
at least
couple
2
years.
years. Yeah.
Okay.
And again, this would be phased in gradually. You know, I've proposed perhaps the first phase would be freezing increases in expenditures, and finally bringing back the force of that rule.
Great, thank you so much. On your other proposal, you kind of referred to one-stop reconciliation with regard to the allowing votes on mandatory programs. As far as the process goes, reconciliation only takes 50 votes plus one in the Senate, but any appropriations bill would be subject to the 60-vote threshold. So how can we be sure that any proposals we would move would even be able to get through the Senate?
Well, we can't be sure of that now. Under the current rules, we can't be sure that appropriation bills are going to be taken up in the Senate, and the Senate may decide to work its will. We've got a conference process. It's very good at identifying and reconciling the differences between the two houses. The point is this: the Appropriations Committee has been very effective at marking to the budget levels for discretionary spending. They've often rightly and proudly boasted of that success. And as I indicated, we've brought down the discretionary spending that's under the direct control of the Congress. The problem is they are completely powerless to mark down to the mandatory spending levels called for in the budget. And so, despite all the work on the discretionary side, we continue to see the budget spinning out of control because we can't touch the mandatory programs without separate standalone legislation, which in this environment becomes extremely difficult to pass. Put it together with the spending bill so that you get the savings along with the spending. I think that that's a streamlined process that actually allows us to stick to the budget numbers that we've set before we bankrupt our country.
Sure. And to follow up on, you had said that in your testimony that the measures would be annual and temporary, I believe was the word you used.
The idea
so
would
it would
be
only apply for that Congress, and it could only go down to the numbers approved
Set by
in
the
the budget
budget.
resolution
Correct.
for that year, for that program. Is that correct?
Correct.
Okay. So I just wanted to understand, so the changes would expire at the end of the fiscal year, and then you'd have to do it
The idea
again in the
is-
next year
The idea
to mark
is
it down.
to give the Congress the full power to stick to the budget numbers that it has established.
And under the way you envision your rule proposal, the amendments to the appropriations bill would not have the ability to reduce programs below the budget number in the budget resolution that is effective for that year. Is that correct?
Correct. And by the way, this would only be effective if we have already voted to enact a budget setting these numbers.
So if an amendment under your rule was not just limited to that fiscal year, it would be ruled out of order under the way your rule would be proposed. Is that correct? So are you envisioning amendments that would cut a specific dollar amount, or maybe make programmatic changes?
They would make programmatic changes to the underlying statutes to the extent that they are necessary to bring the spending to the budget numbers already enacted by the Congress.
So envision with me, if you will, remember back to our appropriations process last year and every year since I've been here, we've had, I know you were here 2 years before me, we have an open rule process on appropriations bill generally, which means things move fairly fast. How can we ensure through this process with these amendments that we would get the relevant CBO and budget committee determinations, on an amendment? I guess, have you thought through that and what that might mean, given that it'd be a fast-moving process?
Well, it would be a fast-moving process was brought to amendment. The idea would be that we would incorporate into the appropriations bills the statutory changes necessary to bring spending to the level set by the budget, both on the discretionary side as a current process and the mandatory side, which is currently forbidden.
Great. So my next question is for Mr. Griffith. How do you propose that your rule would work? Would it work just like it worked until 1983?
I would propose that that would be the case, and all the precedents from the rule's inception, roughly 1876 through 1982, that precedent would still be standing because we didn't change the language substantially. There's, like I said, in the earlier rules, there's an order difference, but the language is substantially the same as what we had for over 100 years. It seemed to work during that time period. There's lots of precedent that the parliamentarians can use, and I would submit it would work the same way. And I would also submit to you that while I know there are multiple reasons why we've gone from 59, when the last year the Holman rule was in effect, to 456 amendments, one of those reasons might be that there's just a tremendous amount of frustration that they can't get to other things, so people look for all kinds of little changes in the section of the budget we can get to, because the mandatory spending is the lion's share of our budget, and that if you had opportunities. Now, let me make it clear again, there's only 3 categories, and so it's not like you could change an entire program. You could affect a program by reducing salaries, reducing the number of employees that might affect the program, but you wouldn't actually take the program off the books unless you went through the regular order of that. But this was regular order. It's what they worked out. They started, figuring out what they could do. Someone raised the question, why just reductions? Well, the concern there was that, you've only got so much money, and when this rule evolved, it was, okay, we can do retrenchments if that's where people want to go, but you better have authorization. If we're going to spend big chunks of new money, that needs to be studied carefully. But a retrenchment was considered appropriate, and it served our nation well for many, many years. And as I said, as much as we hate to go back and rehash a prior political event, I have spoken to some of the Republicans who were in office at that time, and they've indicated that their view was it was an attempt to stop some changes that Ronald Reagan was proposing, and that House Republicans, along with their colleagues, some of their colleagues on the Democrat side of the aisle, Democrats still had control, had been very effective in the first couple of years of the Reagan administration. And this was a way to put a stop to it, because then you couldn't go in and say, okay, we're going to do this or that. All you could do is affect the money. And here's where it tilts the power to the administrative branch of government. I don't care whether it's a Democrat or Republican administrative branch. It tilts the power to them, because now all we can do is limit the money going to a particular area, sometimes with many programs under that particular item. And then the cuts are then decided by, whether or not you keep this many employees, what you do. All of that is now decided by the administrative branch of government. I would submit that under the Holman Rule, although I have no examples to give you today, but I would submit that power was a congressional power that we ceded in 1983, which I don't think was appropriate. But it does, we talk about this would make things more partisan. The failure to have this language started off with partisan origins. And today what I'm trying to do is to restore it to a rule that existed during both a big chunk of Republican hegemony over the votes in the House, and then a period of years where the Democrats had control and significant majorities in the House. And so it worked for both Democrats and Republicans before. It can work for both Democrats and Republicans again. More importantly, it works for the people of these United States because it's a fairer process. It lets the floor and the Appropriations Committee have more power. And the gentleman was correct when he said he's arguing against more power for the Appropriations Committee. That too is true.
Well, and I was going to ask you, and you already said you don't have any examples of when, you don't have any examples in front of you when the Holman Rule was used and effective?
Well, I do have some examples of things that were proposed to be cut that were in my statement. I have to go back and find that.
Yeah, I was wondering if you could give me any examples of when it was actually used to cut things, not just proposals that were then defeated.
Well, and I don't know. Those were held in order. I don't know whether the votes were successful or not. It was held. parliamentary precedent tells us that there was a challenge to whether or not that was appropriate under the Holman Rule, and the ones that I mentioned, it
Were upheld.
was appropriate. Whether or not the votes were there or not, I don't know. I would submit that on occasion, although rare occasion, it was probably successful. The resistance you see to the rule is exactly why you won't have hundreds of amendments that actually pass. The authorizing committee, if it's not something that they've studied or care about, they're all going to be against it. You're going to have a group that proposes it. Authorizing committee is probably going to be against it. In some cases, if it's a floor amendment and not an amendment coming out of the Appropriations Committee, the appropriators are going to be against it, whether they're Democrat or Republican, in the majority or in the minority. So it's going to be difficult to pass the amendment, as it should be. But if it is the will of the respective members of Congress representing all of the states to make a retrenchment in those 3 specific areas that are allowed under the Holman Rule and under my restoration of that Holman Rule, then that is good government, and it should go forward. And so, we haven't studied what kind of cuts were made, because contrary to some folks' opinion that we're trying to cut specific types of programs, that's not the case. What we're trying to do is to reestablish the authority of Congress to go in and not just say we're going to cut the money to program X, but that we think that you've got too many employees, and that's where you ought to make the cut. And then you may also have a respective money cut, or you may cut the number of employees and put that money into programs that go directly to the people, as opposed to having being spent by bean counters or others in D.C.
Great. Mr. McClintock, one last question for you. From your perspective, what's wrong with the Army protocol that Mr. Cole brought up in the process now for unauthorized expenditures?
I think the Army protocol is a very good practice. I'd like to see it in the House rules, but I don't think it alone is adequate to provide the Congress with the tools that it needs to stick to the budget numbers it's adopted.
Great. Mr. Price, one question for you, and then I'll give it to Ms. Slaughter. In your testimony, you state that time has proven that the 25th Congress was correct in adopting Rule 21 and preventing a delay in the appropriations process over proposals of legislation. The Holman Rule, which has a long history, first adopted in 1876 by Democrats, actually, and then turned off in 1895 to 1910, then reinserted in the House rules from 1911 through 1983, is very similar to the proposal that Mr. Griffith would restore to the pre-1983 rule. Why do you have any legislative history on why it was changed in 1983 and why we should not turn it back on?
My understanding of the changes in 1983, leaving aside the political motives that Mr. Griffith has attributed to this, I have no evidence one way or the other on that. My interpretation of the change that was made in 1983 would be that it was a further tightening up of the distinction between authorization and appropriations, and that in that respect it appears to be consistent and appropriate. But I think we need to back up a little bit. The Congress made a decision almost at the beginning to separate the authorizations and appropriations process. Now, admittedly, not every parliament in the world does that, but we have done it. And I would submit that that separation has served us so well. In any event, it'd be a radical change, and I'm particularly going here by what Mr. McClintock is envisioning. It'd be a radical change to have the processes once again combined. And as I'm listening to our two friends here, I don't believe they're talking about the same thing. I mean, the Holman Rule is one thing. That's a rather narrow provision which might or might not be tweaked. But as I hear Mr. McClintock talk, I envision the Appropriations Committee becoming the arena for considering the whole gamut of the Social Security program, the Medicare program, the Medicaid program. I mean, the distinctions would come down between mandatory and discretionary spending. I stand to be corrected on that, but I could imagine the appropriations process being totally gummed up by whatever people wanted to bring up in committee or on the floor with respect to changing this or that entitlement program. So I suggest we just back off and look at this historical decision, which has been with us for a couple of hundred years, to separate appropriations and authorizations, and to and as the founders of this distinction stated, to not let annual appropriations be held hostage. They didn't quite say it that way, but that's the idea. Don't let annual appropriations be held hostage to disagreements on legislation. Or one might say to the obstruction of legislation or gridlock on legislation, because we have to pass a budget each year. The government shuts down if we don't. And goodness knows we have enough trouble with that process already. But the notion that you would fix it somehow by importing authorizations into this whole process and adding that whole gamut of controversies and difficulties, it's just inconceivable to me that this would work in any kind of positive way.
Thank you. Now I yield to the ranking member.
Thank you very much, Mr. Stivers, and I really learned a lot here today, and I thank all of you for a good discussion. When I first came, I obviously came down on the side of Mr. Cole and Mr. Price, and I think all of you made a good case, but I continue to stand with my first statement that this is too draconian for us to do. And if I might speak out of order for a moment, I would like to acknowledge the presence of Tom Wickham, who is the House parliamentarian, who is a consummate professional, recognized by both sides for his expertise and his fairness. And his visits up here are rare, but very, very welcome. So I yield back the balance of my time.
Now I'd like to recognize Bradley Byrne, our distinguished gentleman from Alabama.
Thank you, Mr. Chairman, and I appreciate everybody being here today. I was taught in college not to be an ideologue. I was taught to think through issues. I sometimes think that we are teaching college students today to be ideologues, but that's a different topic for another time. So thinking through these issues and not being an ideologue. Let me ask you a question, Mr. McClintock.
Only if it won't send me fleeing to the committee safe room.
Yeah. The rule is very clear. We are not supposed to be appropriating to that which has not been authorized.
Correct.
We get around that by waiving the procedural point of order, correct?
Correct.
And what you said earlier was we want to not just slam the door right away, but create enough time where our authorizers can do their jobs.
Exactly.
And I think we should assume in good faith that they're going to do their job. So what if we just said, the Rules Committee said today, that on January 1, 2018 and going forward, we're not going to waive the point of order anymore. That gives our authorizers a little over a year and a half to authorize it or not. And I think after that period of time, it would be fair to assume if they haven't authorized it, that their failure to decide is a decision in and of itself. Mm-hmm. What do you think about that?
I think that'd be a huge step in the right direction. You know, again, if there are vital programs that are unauthorized, the opponents of this proposal are absolutely correct in that respect. But I would have to think that those programs enjoy broad bipartisan support. Reauthorizing them would be a very simple matter. And if a program after 2 years can't be reauthorized, maybe that's nature's way of telling us that it is superannuated and ought to be let alone for a while.
Well, that's kind of the way I looked at it. One problem up here, I've only been here 2.5 years, is that inertia takes over, and we just kind of let things keep on going the way they've always gone and think that that's okay.
Right.
The American people are screaming at us right now. It's not okay. Mm-hmm. Democrats are screaming that. Republicans are screaming that. Status quo is not okay.
And if it's not worth the time and fuss and bother to reauthorize, maybe it's also not worth the money that we're shoveling at it.
Right. Well, and I dare say there's some of these programs and departments and agencies, et cetera, that if we took it out to the American people and let them vote, they wouldn't, Democrats and Republicans would have broad bipartisan agreement. Why are we doing that? Because it doesn't get to what people need for their everyday lives. Let me follow up on something because I wanted to make sure I understood something you said. And this is with regard to what you were talking about mandatory funding in appropriations bills. When the chairman was asking you about potential complications with availability of the CBO data and House Budget Committee guidance during the amendment consideration of the floor, I believe I heard you say that would only be the case if we allow amendments on the floor to affect those changes. Does that mean that you're only requesting that the Appropriations Committee have the ability to report changes in mandatory spending, or are you advocating floor amendments?
Both, but I would be content to limit it to committee action. Again, when the budget is adopted, there are CBO scores on all of the provisions involving the mandatory spending, the reforms necessary to effect those savings. Placing that in the appropriations process then allows us to take action, as we currently do on the discretionary side, to take action on the mandatory side as well.
Okay.
And those CBO scores, I believe, are available in the accompany the budget.
Mr. Griffith, let me ask you a question. I know where you're trying to go. I want to go there with you, but I'm having a little problem with where you're trying to get, how you're trying to get there. I think there's a big distinction, both in substance but also in the practical reality of how things work, between mandatory spending where people have paid into a program like Social Security and Medicare, and all those other mandatory spending programs, and you've got the list that you're trying to compile, which may not be complete. I think that's a pretty big substantive distinction and a pretty big practical political distinction. So I wonder if, in thinking through what you're trying to do, if there's some way to make that very important distinction that, as you said, would affect $2 trillion of what we're presently spending. So I just throw that out there if there's some way for us to practically understand that I don't think anybody around here wants to, without having a pretty thoughtful, deliberate process that's gone through committees and all that public hearings and everything else, to start making anything like a significant change to those two programs. Does that make sense to you at all?
Well, it does. Now, you wouldn't be able to affect the general tenets of the program. You could affect the employees who were working on that program, and that could have the indirect result of affecting that program. I grant you that.
Yeah.
I would submit to you that, as I said before, it's going to be very difficult on particularly on something complicated like that. You'd be very difficult to get passage on the floor to begin with, which is why I don't think it was a major problem up until the rule was changed, because it does take a tremendous amount of effort to make a change when you've got the authorizing committee that's most likely going to be opposed to you, et cetera. That being said, while I think that going back to the Holman rule is the appropriate way to go, if you wanted to pick out a program or two and say that could only be done in the committee, because I'm changing both 2B and 2C. 2C deals with the floor, and then there's a clarifying amendment in 2D. 2B deals with the appropriating committee. You could put something in there like that, or you could just say you couldn't do it. That wouldn't be my preference, but obviously, if there was great concern and we could try it out as a experimental program or a test case to see if going back to the Holman rule caused the chaos that some of my colleagues have felt that it would, we could try it by making some distinction in which programs of those really big ones. And Social Security clearly is a different animal. Medicare has different components to it, and I recognize that. Then there's all the other programs. And many of them, I mean, I've looked at the list that I've got to the best of my ability to figure out where things are in there, and
Right.
There's a lot of them that I wouldn't vote to do anything to. There are some that I would, and it's the fact that we don't have the ability to get to it in what was the regular order for many, many decades. I think that we ought to be able to do that. That being said, if it's the will of the House that we go with this as a test case and we set aside a couple of programs and leave the other hundreds of programs out there to be examined by the membership, I certainly wouldn't say that was a bad step. That certainly would be a step in the right direction.
I'm just speaking to you like a regular old rank and file member. I wouldn't feel comfortable with any process that would have any sort of a significant effect on Social Security and Medicare. They didn't go through an extremely thorough hearing, deliberative committee process, et cetera.
And I would agree with that. And let me just make it clear so there's, and I know you know this, but I don't want anybody taking out a little soundbite and thinking we've said something different. I wouldn't vote for one of those amendments.
Right.
But the opportunity to offer an amendment is different than actually approving of the amendment. And all I'm saying is that as members elected by our respective congressional districts, we ought to have more ability to impact this process as was done for, 100 years, and that didn't seem to cause chaos or the destruction of the Republic.
I'd like to ask Dr. Price, Professor Price, and Professor Cole, what do y'all think about the Rules Committee saying, look, we've been waiving this point of order, but as of January 1, 2018, we're going to stop waiving the point of order. Doesn't that give our authorizing committees plenty of time to get their job done and tell us what should be authorized and what shouldn't?
Well, I do think we have a problem with way too many unauthorized programs. I'm reluctant to paint with too broad a brush. I do think from time to time there are good reasons for that as well as bad. There are certainly some persistent problems that leaders in both parties could testify to as to finalizing some authorizations, like that State Department authorization.
After a year and a half?
I think the historical record's pretty clear that some of this is pretty difficult stuff and not probably solved by simplistic remedies. Having said that, I'm all for exerting pressure, and I would hope pressures from within the authorizing committees themselves. I mean, these people didn't join these committees just to sit there, right? They chose to be there because they presumably would be writing legislation. So I'm not making excuses for those committees, but I think to condition the appropriations process on the completion in each and every instance of the underlying authorization would be just an invitation to, if you think gridlock is bad now, that would be an invitation to just shutting this place down, or certainly shutting the appropriations process down. And let me just say, I agree with you, Mr. Byrne, about the way the public views a lot of this. So I think our constituents want to see, they don't want to see programs just indefinitely continued, but there is nothing that gives any kind of privileged position right now to unauthorized programs. On the Appropriations Committee, on the House floor, we can cut and cut and cut those programs if that's our political desire. So there's no privileged position that these programs have by virtue of being unauthorized. There's no immunity that they enjoy. So if the point is to get at authorized or unauthorized programs, the appropriations process provides a perfectly viable way to do that.
But and I want Dr. Cole to speak to this, but it seems to me that I'm not proposing changing the rule. I'm proposing, after a year and a half time, enforcing the rule. So what's wrong with that?
Well, I don't, I'm like my friend Mr. Price. I'm loath to tell you that I'm not in favor of finding ways to get the authorizing committees to reauthorize. But I do want to pick up on a point he made that I was going to make as well. We do cut spending for unauthorized programs all the time. We cut, the State Department hasn't been reauthorized. If you go back and look at foreign aid, we cut 24% out of foreign aid. So, and there is considerable expertise on these committees in the areas we don't have to wait around on appropriations for the authorization guys to do something, to act within the sphere that we have. I would suggest our members on defense of probes, with all due respect, are every bit as knowledgeable about the defense of the country as the members on the House Armed Services Committee. They actually probably go to at least as many hearings, and since they're so much smaller, they interact a lot more with the witnesses, having been on both armed services and now on defense of probes. And I could say the same thing on natural resources, where I served, and now interior probes. So I'm not saying the authorization thing isn't a problem, but it's not a silver bullet either. going through the authorization, it's not as if we haven't tried to save money in state since the last time it was authorized. And it's not as if we haven't cut and changed appropriations. So I think we can get too hung up on that point. Second, you do empower, an obstructionist minority, perhaps, and I don't mean that aimed at our colleagues in the minority. I mean anybody that just wants to gum up the works in an authorization committee. I saw this happen, frankly. Mr. Simpson, when he was chairman of the Interior Committee, tried to force the authorizers to reauthorize the Endangered Species Act, to just go through it. We think it's a problem area, and he was going to withhold funding. And the authorizers, for whatever, it's highly contentious, it's highly partisan, it's been used in political campaigns to defeat members on both sides of the aisle, simply couldn't get it done. Now, I suppose we could have just gotten rid of the entire program, but our own leadership said, no, you can't do that. That would become an issue in and of itself. So these issues become complex, and I suggest that appropriations is not a tool to discipline the other committees. That's not its function. You need to get the other committees to do their job. Now, as Mr. McClintock, and he's been great about this, honestly, pointed out, look, when we get a number from the Budget Committee, we live within the number whether we like the number or not. And we have made substantial reductions and cuts, and sometimes, again, in things we didn't want to do. I've been here for many years. I voted against Obamacare in every iteration. I've never seen a substitute produced out of the appropriate committees. I've watched these committees do Medicare Part D or Obamacare. It's not as if they can't function legislatively, but they don't want to pick up entitlements and deal with entitlements, and that's 70% of the spending. So I don't think us withholding appropriations, which might affect the defense of the country or some other important day-to-day function, you're also putting the American people at risk here. You're not just putting an authorizing committee at risk. They didn't do their job, and we didn't fund the military, then who's at risk? The American people are at risk. So I don't think you blackmail your own people, but there has to be a way, and I would love to work with my colleagues on this, to encourage or incentivize authorizing committees to do their work. But end of the day, remember, the unauthorized appropriations are certainly a tremendous amount of money, $310 billion. That's in a $3.9 trillion budget that's over $500 billion out of balance. So you could reauthorize them all, and you would still have a substantial deficit. The real issue is, hey, when are we going to reform Social Security the way Ronald Reagan, Tip O'Neill, and Howard Baker did in 1983? When are we going to sit down and look at Medicaid? Now, we do this in the Budget Committee. Budget Committee has, advanced programs in Medicare and Medicaid reform, very highly controversial, very, very spirited debates. I've never seen those things picked up in the appropriate committees of jurisdiction. When the Budget Committee gives us a number, we're living within the number. So the other committees have got to figure out a way just to do their work. I would be a lot more impressed if I saw them. And again, we've seen major legislation. Never a problem around here to move tax bills. My friend mentioned tax expenditures. Okay, if you're going to do that, why can't you pair that with a mandatory spending bill? If you're going to cut taxes, okay. Over here, you're leaving the revenue, you're leaving the expenditure part of this that you control totally unaddressed. Now, I'm not advocating you have to offset tax cuts with additional spending, but there's no linkage whatsoever. So I see bills coming to the floor to cut taxes. I never see bills coming to the floor to cut not cut, but reform Social Security. The same thing with Medicare, same thing with Medicaid. Again, Budget Committee wrestles with these things. They vote on them. They put their fingerprints up there on them. A lot of members do. Why can't those committees do it? So, but again, I would urge you, and I know I've gone on a long time, don't use the Appropriations Committee to discipline every other committee because it hasn't done its job. And the only reason why we're doing that is because the Appropriations Committee has done its job. It has lived within what this body collectively told it to live within. Last point I want to make, and this is somewhat unrelated, but I think it's important. There's two things I think you need to look at when you look at both these proposals. One is how much do you want us to do? Do you really want us as an Appropriations Committee to become experts on Medicare and Medicaid and Social Security? In addition, we already have the range of the entire discretionary part of government where we have blocks of expertise in each of our committees. So you're going to now have to both enlarge the committee and create new areas. We have no expertise. I have strong opinions about Social Security, Medicare, and Medicaid, but I don't pretend to know as much as the people in the relevant committees. Do you really want to trust me to do that job? It's going to take a long time.
But under my proposal, that wouldn't get to that.
No, that's true. And this is, as I said, this was an unrelated, I thought it was an important point to make. And you need to think, you would really, under these things, put everything under our control except the raising of revenue and whatever taxes were. We would control everything out of that single committee.
Well, if I followed your line of reasoning then, if we're not going to enforce the rule, why don't we keep the rule the way it is? Why don't we change the rule and say it's okay to appropriate things that haven't been authorized? Because the rule right now says we're not supposed to.
That's true. And again, I'll leave it to this committee. I'm not coming up here arguing that one way or the other. All I'm saying is when you do that, if the job doesn't get done by that authorization committee, don't think you're just punishing the authorizers. You're punishing the American people who are supposed to be getting some sort of service or some sort of benefit.
I'm not trying to punish anybody.
Oh, well,
I think the American people are being punished by our failure to get control over our spending.
I would agree with that wholeheartedly, and would put my record on those things up on the line with anybody else's. I agree with you, but stopping functions of government because something hasn't been done is essentially a sort of governmental shutdown in miniature in a particular area. That maybe that's what you want to do, but you're putting at risk people that have no part in that process, that have no mechanism to enforce it or to defend themselves from it. And I think long and hard. Look, I don't think the day would come we would not authorize defense. I have enormous respect for people in the armed services, but what if it did? What if it did? And so you're really shutting down whole functions of government. It's not just a legislative process here, it's reality out in the field where the rubber meets the road. That's a high risk to take. Maybe the only way, but I just want to point out that's a high risk to take.
Well, I've monopolized a lot of time here. You brought up the Endangered Species Act. I've got people in my district whose livelihoods are being challenged by what I consider to be the inappropriate use of the Endangered Species Act. So, and they get no fair hearing in front of the people and the relevant agencies who are involved with that before their livelihoods are put at risk by what I think is a total misinterpretation of that. But because we've legislatively delegated to that agency that authority, then we've lost the ability to control it. We, the Congress, the people that are elected by the people to make sure that the people's will is enforced. And perhaps the only way we have of controlling that is by using the power of the purse. Well, so I think there are certain programs that if you went to the people in America and said, do you want these to continue or not? The people in America would say, no, if that's the way these agencies are going to use them, if they're going to go way beyond what they've ever done before. Now, I will say this. Bad facts make bad law. In the last several years, we've had some terrible facts. And part of what's driving this is the American people are just had enough of what's been happening out there with the overassertion of federal authority. And if we can pull back, then we may not be having the sort of discussion we're having today. And I apologize for speaking so long, but I think this is critically important.
I think it is too. Let me respond because I suspect we agree 100%. In terms of the inappropriate exercise of power and bureaucracies. Now, on the appropriation, let's just take the Environmental Protection Agency, probably one of the more controversial agencies. It's operating with 22% less money than it had in 2010 and at 1989 staffing levels. And that was driven not by anything the authorizing committee did, but through the appropriations process. But if we need to do something, why can't the Natural Resources Committee, where there's enormous expertise, simply pass a law? Now, it may or may not get through the Senate. We've actually cut in the House EPA more than 21%. I think we've cut it in the mid-30s, but those cuts get partially restored in a negotiation process with the Senate and the administration. But again, I don't see how any of this is an excuse not for the authorizing committees to simply do their job. And if you can't get it through the Senate, or we'll still do our part. We tend to philosophically agree when we're in the majority. We philosophically agree with what our friends on natural resources are trying to do, or our friends on armed services are trying to do. So we'll use that. But again, using the funding of day-to-day government to discipline a committee because it either hasn't authorized something or has not achieved a policy objective puts the day-to-day functioning of government at risk, creates enormous problems in terms of moving any kind of appropriations bill through. I mean, it literally is. And I know my friends mean this in the right way, but again, how powerful do you guys want us to be? Because you act like it's going to be the Congress that does it. Believe me, these decisions then will be made largely inside the Appropriations Committee, and you will have enormously expanded our power, I guess because you trust us, because we've been able to bring down discretionary stuff. But I think that's too much power. That, Congress itself, there was a time when all taxing power and all appropriations power was in the same with the old Ways and Means, before appropriations was created. And the sentiment in the body then, that was too much power. That was way too much power for one small group of people to have. So I do think it's worth asking these deeper questions, because the frustration is going to lead you to making us stronger than I would argue we should be. Now, again, we're like anybody else. I guess if you give Frodo the ring, he'll put it on. But do you want to give him the ring?
Well, I've taken up too much time. I would just say my proposal would take power away from the Appropriations Committee, because it wouldn't allow you to appropriate to things that aren't authorized. But I yield back, Mr. Chairman.
Thank you very much. That was a great exchange. I now recognize the gentleman from Massachusetts, Mr. McGovern.
Yeah, well, I'm not going to, speak for very long here. As I'm listening to this, I can't help but think that that this is not a House rules problem. That the dysfunction that exists here, the inability to get authorization bills passed, the inability to do a lot of what the American people want. I don't. We can blame it on the House rules if we want. We could say that there's a magic silver bullet, or we can, try to, concoct a system that essentially forces us to do certain things. But this really isn't a House rules problem. I mean, and I don't want to be partisan here, but I mean, you guys are having trouble with the budget right now. That's not a House rules problem. That's a problem of ideology within the Republican conference. The problem with some of these authorization bills is that they have become polarizing debates, that extremes have kind of taken over, and they go so far one way that it becomes impossible to get a majority to support them. That has nothing to do with House rules. If you want to cut, I mean, SNAP, which I know a lot of my colleagues do, you had the opportunity to do that in the Farm Bill, and you did. You cut it by $8 billion. You voted initially to cut it by $40 billion, but you cut it by $8 billion, which I think was unconscionable. But there was the opportunity to do it. Now, some people think that we should cut it even more deeply. Well, I think you wait for the next Farm Bill or the next appropriate vehicle to be able to do that. But I mean, I don't think this is a House rules problem. I think this is. If people are frustrated with the way this place runs, look in the mirror. I mean, those of us who serve here, I think, need to kind of figure out a way where we get back to a time where we don't have to get everything we want. Even the budget agreement that the Speaker, helped negotiate, last year is now coming under attack. And we're not quite sure whether we can proceed when the election is over with. So, I think this is more an issue of the people who are getting elected, who are coming here, are moving more and more ideologically to one side, but so far to one side that it's, quite frankly, out of the mainstream of where the American people are. We ought to have appropriations bills. The appropriators we ought to have authorization bills. The authorizers ought to do their job. But I don't think you're not getting them because the chair or the ranking member of the authorizing committee don't want to bring a bill to the floor. It's some of the amendments and the nitpicking and the polarizing issues that get all attached to these bills that make it very difficult to be able to get them passed. But I'd like to get back to a day where we can, figure out how we can work in a bipartisan way to get legislation that, again, may not be everything I want, may not be everything you want, but reflects genuine compromise. You don't have to agree on everything to agree on something. And we're at the point now where there's something we agree on is never enough to move it forward on the House floor. So I don't think, I appreciate my colleagues coming with these ideas. I think it's very interesting to talk about them. But to the extent that this place doesn't function right, I think it has more to do with the makeup of the membership than it does with the House rules. And I think we need to figure out a way to kind of get back to the concept where getting legislation done is actually, a goal that we both share. The problem is that the incentives in this place are not to compromise, are not to get a deal. It's always to have a fight. And I think that's, when you talk about the American people being frustrated, they're really frustrated because we don't seem to be able to get anything done. And we do the minimum. We get our appropriations bills done. We usually keep the government running at the last minute. But I think they're expecting more. And again, it's not a House rules problem. I think it's us.
Mr. Chairman?
Yeah.
I wonder if I could
Sure.
respond to what my friend's saying. I basically agree with him, and in fact, I was saying myself in my statement that the political dysfunction around here was a function of ideology and probably wasn't going to be solved by proposals of this sort. But I'd like to suggest that maybe he's going a bit too far, because I think rules can make a difference, and I have an example to suggest. Now, these gentlemen, I think, are doing a good job of trying to figure out what difference the rules changes they're interested in would make, and I, of course, disagree with those particular changes. But let me remind you of one rules change that I think everybody agrees had a great impact, and that was it was part of the 1990 bipartisan comprehensive budget deal with President George H.W. Bush and the Democratic majorities in the Congress. And, though that budget deal set numbers, revenue numbers, entitlement numbers, spending numbers, it did lots of things with numbers, but it also set a rule. And the rule was called pay-as-you-go. And it directly addressed the problem our friends are trying to address here, that is entitlement spending. It set the rules for how the budget reconciliation process would work. And it said, in short, that if you're going to raise entitlement spending, you're not going to be able to do that unless you do one of two things. Unless you reduce entitlement spending somewhere else, or unless you raise revenue. Otherwise, it's a non-starter. You're not going to cut taxes unless you raise taxes somewhere else, or you cut entitlement spending. Those are pretty powerful inhibitions against both tax cuts and entitlement spending increases. And I've suggested to you that was a rules change, and it did work. And we lived with that discipline for a long, long time. And you remember when it was lifted, unfortunately, early in the George W. Bush administration. But I just suggest, Mr. McGovern, that is one area where it's productive, I think, to think about how the rules affect what we do. Although I do believe right now whatever rules we're working with are getting swamped by polarized politics.
And a rule is only as good as whether we follow it. And one of the things that we have done in this committee on many occasions is waive rules, pay-go rules and other rules. And again, we have all these rules, and if we don't enforce them and if we don't follow them, then they lose their, I agree with the concept, but I'm just
Well, my
simply
point
saying,
was that one was
but that
enforced.
goes back to what I'm saying before.
That one was
we're waiving these things, I think, more for political reasons and for ideological reasons. And I go back to what I said. I really do think that at some point we need to figure out a way to regroup in a bipartisan way and to approach some of these very difficult debates. Whether it's dealing with entitlements, which are very, very delicate issues or, our tax policies or whatever in a way where, everything doesn't have to be like we're in the middle of a political campaign. So with that, I appreciate you being here, and I yield back.
Thank you very much to the gentleman. I have a couple follow-up questions before I wrap up the hearing. The first is for Dr. Price, Professor Price. You referred to the 1990 pay-go rule, which I think was a big step forward. Do you recall what the deficit was in 1990?
I can't give you the publicly held.
I'll remind you, I just Googled it. It was $220 billion that year. So
The annual deficit.
The annual deficit that
I
year.
know the deal produced $500 billion in 5-year savings.
So, and it is great that we have pay-go, now cut-go, which a rule we've improved. But the problem with that is it kind of locked in a deficit of about that amount unless you actually make programmatic changes. It prevented you from going above that other than interest and other waiving of the rule, but it essentially made it hard to go below it too. So that's the only concern, but I agree with you, it was better than what we had before. So I just wanted to remind you that. I do have 2 follow-up questions for Mr. McClintock. You had talked a little bit about when you changed mandatory spending, it couldn't go below the budget resolution, it would go to the budget resolution number. What would happen if we'd find ourselves in a situation where the House and Senate didn't agree on a budget number? Would that rule be essentially unable to be enforced because there is no budget number?
Those differences would then be resolved by the normal conference process that has evolved over centuries and is very good at isolating and working out.
Well, there have been years when we didn't have a budget, I guess. So I'm saying if we don't have a budget resolution, in effect,
that's exactly right.
That's what I'm trying to figure out.
The idea behind this would be the budget resolution has to be in place. So we have already voted to enact spending at certain levels on both the discretionary and the mandatory side. As we've discussed, the House has been very effective at marking on the discretionary side. It has been totally ineffective at marking down to the mandatory side because the appropriations, because of, Clause 2B forbids that. And the ironic thing is, Clause 2A that prohibits unauthorized spending, we waive routinely, but 2B, that's absolutely essential to get mandatory spending within the parameters set by the budget, we never waive.
So for some of our friends on both sides of the aisle who don't want to pass a budget this year, it would render this change
Well, the budget would
worthless.
Yes, the budget
We need
would
a
be
budget.
essential, exactly, and we do anyway.
Yeah, we do anyway. I agree with that, but it would help increase, I guess.
And again, the source of my frustration is we had a budget that set numbers, we couldn't stick to those numbers. Why can't we stick to them? Well, a big part of that is we don't have direct control over the mandatory expenditures. I mean, Mr. Price is absolutely right that pay-go was a very good reform, but that only constrained changes in the entitlement programs. The problem is the entitlement programs haven't changed, but they're dramatically expanding. That's what's pulling us so far out of balance. And I do want to make a distinction between that and, again, the trust fund, Social Security and the portions of Medicare funded by the payroll tax. That's a separate issue. It's still very important to resolve, but it's not a direct budget issue. I'm talking about the $1 trillion that goes out a year, roughly $1 trillion that goes out a year, that we don't have any direct control over.
You're not talking about Social Security and you're not talking about Medicare.
Right.
Right. Gentleman from Virginia, Mr. Griffith.
And Mr. Chairman, I would submit that of course, I would prefer a change, but either a change, a waiver of 2B or a return to the Holman rule would put a number of avenues on the table that would allow us, I believe, most fervently, to get a budget. I don't think that would be any problem whatsoever if you had that as one of the tools that the House could use. And currently, there's, as my colleague said, there's a waiver of 2A on a regular basis, but nobody ever wants to waive 2B, nor do we want to, at least up until now, want to change it back to the original Holman rule. Either one of those would give us so many different avenues that I think we could have a resolution, could have had a resolution weeks ago.
Great, thank you. And one last question for Mr. McClintock. So you talked about consultation with the authorizing committee. Do you envision that the same way the current Army protocol works or some other way? How would the Appropriations Committee under your rule consult or get consultation with the authorizing chair or committee?
Well, as I said, I would obviously advocate the broadest application of this principle, but would be quite content if it were simply done through the committee process. The budget enacts mandatory spending at a certain level, calls for certain reforms to bring that mandatory spending to that level, and in the absence of standalone legislation, the Appropriations Committee, with the advice and consent of the Authorizing Committee, would make those changes in that statute necessary to bring us within the parameters of the budget.
So
That's-
how does
that's
that,
the
what is
fundamental
that advice
proposal.
and consent, and how does it work? What would the appropriations, and, you know, they talked about how powerful this could make the
Again,
appropriations
budget.
committee. What would they,
Once the budget is enacted, it calls for certain reforms in mandatory spending and certain levels of mandatory spending. Those reforms would then be within the purview of the Appropriations Committee to place into the appropriations bill.
so the assumptions under the budget resolution would have to be enacted
Yes, and the Army protocol.
as a way to get?
And the Army protocol, which facilitates communication between the authorizing committees and the Appropriations Committee, you know, could certainly be harnessed for that purpose as well.
Okay, so, because there would have to be changes to reduce the number. You can't just put a number in, you got to say how you're going to get to that number.
Which is what
So
the
that's
budget does.
what the consultation would be, and it would be with the chairman or the entire committee? Would there be some kind of referral or hearing of a committee with notice? I'm trying to understand how this would just
Those are
work.
details that would be worked out. I mean, the Army
Okay.
protocol does serve as a
means.
template for that, and as I understand it, that is the authorizing committee chairman, who presumably is in communication with the majority of the members.
Sure, and I'm not trying to be difficult, I'm trying to understand
no, I
how it would
understand.
work.
Yeah.
I'm just trying to ask questions about how all these things work, so we can then work out the details and figure out what it would mean, and so we can understand how that rule might work in the real world. We certainly appreciate all four of you being here. I think it was a very robust and thoughtful discussion. I appreciate the two proposals and the gentlemen for their hard work in trying to figure out how we can make the House work better, how we can navigate the intersection of authorizing and appropriating committees in a thoughtful way. And I appreciate the gentleman from the Appropriations Committee from giving their perspective as well. This has been, I think, a great opening hearing on the ideas of how we can improve the House rules, and we will definitely continue. We have 3 more hearings we're going to have, I think. So I really appreciate the thoughtful input, and thank you so much for all your help with that. We will end the hearing.